This is part 46 as far as our lecture series is concerned. In the last part, we dealt with the provision regarding appeals right from section 372 up to section 394 of the Criminal Procedure Code. And in this part, we shall be dealing with the next chapter, namely chapter 30. And to understand this, we shall be starting right from section 395 up to section 405 of the Criminal Procedure Code. And by reading this chapter in order to understand this chapter, we shall be dealing with two provisions, namely what do you mean by reference and what do you mean by revision. As far as the reference is concerned, that is dealt by two sections, namely section 395 and section 396 of this chapter, and right from section 397 up to section 405 of this chapter deals with what do you mean by revision. Now, if you read section 395, which says reference to High Court, it says, subclause 1 says, where any court is satisfied that a case pending before it involves a question as to the validity of any act, ordinance or regulation, or any provision contained in an act, ordinance or regulation, the determination of which is necessary for the disposal of the case, and it is of opinion that such act, ordinance, regulation or provision is invalid or inoperative, but has not been so declared by a High Court to which that court is subordinate, or by Supreme Court, the court shall state a case setting out its opinion and the reasons therefor, and refer the same for the decision of the High Court. In this section, explanation says regulations means any regulation as defined in the General Clauses Act of 1897 or in the General Clauses Act of a state. And then subclause 2 says a court of session or a metropolitan magistrate may, if it is, or if it or he thinks fit in any case pending before it or him, to which the provisions of subsection 1 do not apply, refer for the decision of the High Court any question of law arising in the hearing of such case. Subclause 3 says, any court making a reference to the High Court under subsection 1 or subsection 2 may, pending the decision of the High Court thereon, either commit the accused to jail or release him on bail to appear when called upon. So this is as far as section 395 of the Criminal Procedure Code is concerned. Now, regarding disposal of the case, as far as such reference is concerned, when it has been referred, is dealt as far as section 396 is concerned, which says, subclause 1 says, when a question has been so referred, the High Court shall pass such order thereon as it thinks fit, and shall cause a copy of such order to be sent to the court by which the reference was made, which shall dispose of the case comfortably to the said order. And subclause 2 says, the High Court may direct by whom the cost of such a reference shall be paid. So this is as far as reference is concerned. When it's a question of constitutional validity, that is required to be determined either by the High Court or by the Supreme Court, and when it is not decided, then the matter can be referred to the High Court by the lower court, and then the two sections, namely section 395 and section 396, come into operation as far as the reference is concerned. Now, right from section 397 onwards are the sections which deal with revision. Now, during the course of time, when we dealt with that a person can prefer an appeal, or appeal shall lie provided it is provided by the provisions of the Criminal Procedure Code or by any other law for the time being in force, otherwise not. But when, in other words, we have learned that unless there is provision of appeal, the question of preferring an appeal doesn't arise, and hence when there is no provision of appeal, what is the remedy that is available to an individual to go to the higher court in order to challenge the decision which is given by the order which is passed by the lower court, is the question for our consideration. And the answer to it is given by making an application for revision, or as far as the provision regarding revisions which are dealt right from section 397 onwards of the Criminal Procedure Code. If you read section 397, it says calling for records to exercise of powers of revision, and subclause 1 says the High Court or any session judge may call for and examine the record of any proceedings before any inferior criminal court situate within its or his local jurisdiction for the purpose of satisfying itself or himself as to the correctness, legality or propriety of any finding, sentence or order recorded or passed, and as to the regularity of any proceeding of such inferior court, and may, when calling for such record, direct that the execution of any sentence or order be suspended, and if the accused is in confinement, that he be released on bail or on his own bond pending the examination of the record. Explanation says all magistrates, whether executive or judicial, and whether exercising original or appellate jurisdiction, shall be deemed to be inferior to the session judge for the purpose of this subsection of section 398. Subclause 2 says the powers of revision conferred by subsection 1 shall not be exercised in relation to any interlocutory order passed in any appeal, inquiry or trial or other proceeding. And subclause 3 says if an application under this section has been made by any person either to the High Court or to the Court of Session Judge, no further application by the same person shall be entertained by other of them. So if you read section 397, we come to know the power of revision can be exercised either by the High Court or by the Session Judge, and hence the details are worked out as far as this section is concerned, namely section 397 is concerned. Now the further part, what is done by the court exercising revisional jurisdiction is made very clear as far as section 398 is concerned, which says on examining any record under section 397 or otherwise, the High Court or the Session Judge may direct the Chief Judicial Magistrate by himself or by any of the magistrates subordinate to him to make, and the Chief Judicial Magistrate may himself make or direct any subordinate magistrate to make further inquiry into any complaint which has been dismissed under section 203 or subsection 4 of section 204, or into the case of any person accused of an offence who has been discharged. Proviso says, provided that no court shall make any direction under this section for inquiry into the case of any person who has been discharged unless such person had an opportunity of showing cause why such direction should not be made. Now with this, now if you read section 399, which says Sessions Judge's power of revision, and in subclause 1 says in the case of any proceedings the record of which has been called for by himself, the Session Judge may exercise all or any of the powers which may be exercised by the High Court under subsection 1 of section 401. Subclause 2 says where any proceedings by way of revision is commenced before Session Judge under subsection 1, the provision of subsection 2, 3 and 4 and 5 of section 401 shall, so far as may be applied to such proceeding, and references in the said subsection to the High Court shall be construed as reference to the Sessions Judge. Subclause 3 says where any application for revision is made by or on behalf of any person before the session judge, the decision of session judge thereon in relation to such person shall be final, and no further proceeding by way of revision at the instance of such person shall be entertained by the High Court or any other court. Section 400 makes mention of the power of additional session judge, and it says an additional session judge shall have and may exercise all the powers of a session judge under this chapter in respect of any case which may be transferred to him or under any general or special order of the session judge. Now, what are the powers that can be exercised by session judge as far as revision is concerned? For that, the reference is to section 401, namely the powers of the High Court. And hence now, if we start reading section 401, High Court's power of revision, subclause 1 says, in the case of any proceeding, the record of which has been called for by itself, or which otherwise comes to its knowledge, the High Court may in its discretion exercise any of the powers conferred on a Court of Appeal by sections 386, 389, 390, or on a Court of Session by section 307, and when the judges composing the Court of Revision are equally divided in opinion, the case shall be disposed of in the manner provided by section 392. So what are the powers that can be exercised as far as this revisional jurisdiction is concerned? Are the same powers as laid down as far as the court exercising appellate jurisdiction is concerned, with which you are dealt as far as section 386, section 389, section 390 and 391. Along with this, now yet we have not dealt with that, but we shall be dealing with tender of pardon by taking into consideration 3 sections, namely section 306, 307 and 308, and here the court exercising revisional jurisdiction has got power of tender of pardon as far as section 307 is concerned. With this, no, the subclause 2 says, no order under this section shall be made to the prejudice of the accused or other person unless he has had an opportunity of being heard either personally or by his pleader in his own defense. Subclause 3 says, nothing in this section shall be deemed to authorize a High Court to convert a finding of acquittal into one of conviction. Subclause 4 says, where under the code an appeal lies and no appeal is brought, no proceedings by way of revision shall be entertained at the instance of the party who could have appealed. Subclause 5 says, where under this code an appeal lies, but an application for revision has been made to the High Court or by any person, and the High Court is satisfied that the application was made under erroneous belief that no appeal lies thereto, and that it is necessary in the interest of the justice to do so, the High Court may treat the application for revision as petition of appeal and deal with the same accordingly. With this, the High Court has got power to withdraw or transfer revision cases as far as section 402 is concerned, which says, whenever one or more persons convicted at the same trial make application to a High Court for revision, and any other person convicted at the same trial makes an application to the session judge for revision, the High Court shall decide, having regard to the general convenience of the parties and the importance of the questions involved, which of the two courts should finally dispose of the application for revision, and when the High Court decides that all the applications for the revision should be disposed of by itself, the High Court shall direct that the applications for revision pending before the session judge be transferred to itself, and when the High Court decides that it is not necessary for it to dispose of the application for revision, it shall direct that the application for revision made to it be transferred to the session judge. Subclause 2 says, whenever any application for revision is transferred to the High Court, that court shall deal with the same as if it were an application duly made before itself. Subclause 3 says, whenever any application for revision is transferred to the session judge, that judge shall deal with the same as if it were an application duly made before himself. Subclause 4 says, where an application for revision is transferred by the High Court to the session judge, no further application for revision shall lie to the High Court or to any other court at the instance of the person or persons whose application for revision have been disposed of by the session judge. Section 403 lays down provision as far as option of court to hear parties, and it says, save as otherwise expressly provided by this code, or so no party has any right to be heard either personally or by pleader before any court exercising its power of revision, but the court may, if it thinks fit, when exercising such power, hear any party either personally or by pleader. And then section 404 lays down that statement by Metropolitan Magistrate of grounds of his decision to be considered by the High Court, and it says, when the record of any trial held by Metropolitan Magistrate is called for by the High Court or Court of Session under section 397, the magistrate may submit with the record of a statement setting forth the grounds of his decision or order and any facts which he thinks material to issue, and the court shall consider such statement before overruling or setting aside the said decision or order. Now, with this the last section makes mention as to High Court's order to be certified to lower court, and section 405 says, when a case is revised under this chapter by the High Court or session judge, it or he shall, in the manner provided by section 388, certify its decision or order to the court by which the finding, sentence or order revised was recorded or passed, and the court to which the decision or order is so certified shall thereupon make such orders as are comfortable to the decision so certified, and if necessary the record shall be amended in accordance therewith. So these are the provisions as far as reference and revision is concerned, which is dealt right from section 395 up to section 405 of the Indian Criminal Procedure Code. With this now, if we start dealing with the next chapter, namely right from section 406 up to section 412 of the Criminal Procedure Code, this deals with transfer of criminal cases. There can be transfer of a criminal case by Supreme Court, there can be a transfer of criminal case by High Court, and there can be a transfer by session judge too. So this is the chapter with which we will have discussion as far as next part of our series of lectures is concerned.